What are the key estate planning documents every senior should have in place? Can a trust protect your assets? And when do you need one? How can you or your parents plan ahead for a future long-term care need? I'm Ethan Huizenga, attorney and owner of the Huizenga Law Firm PC, and this is the Siouxland Senior Planning Radio Show. Since I'm a lawyer, we've got to start by getting the fine print out of the way. Since legal advice is extremely personal, you shouldn't take anything said on this program as legal advice. After all, I haven't met you, and I don't know anything about you, your health, your family, your finances, your fears, or, most importantly, your hopes and dreams. Instead, my hope is that what you hear on this program will be educational and thought-provoking. Greetings, and welcome back to our Estate Planning Essentials for Seniors series. Over the last several weeks, we've defined estate planning as more than just what happens when you die, and we've identified the four main tools used to accomplish your estate planning goals. Our definition of estate planning goes like this. Estate planning means control while you're alive and well. It means taking care of yourself and your loved ones if you become incapacitated or disabled, and it means giving what you have to the people you want, when you want, in the way you want. We've seen how a will is a tool used to pass your property to your loved ones after you die, but doesn't have any effect while you're still alive. We've learned what it means to appoint an agent using a power of attorney, and we learned about the two types of powers of attorney, financial and medical. Last week, we learned the difference between a healthcare power of attorney, a living will, and a do not resuscitate order. This week, we're going to wrap up this series with a 30,000-foot view of trusts. We'll talk about what they are, and then we'll learn a little bit about how they work. But first, let's start with a few reasons why you might want to use a trust in your estate plan. First, you should use a trust in your estate plan if you have specific goals you want to accomplish. There are at least dozens of different types of trusts, many of which are used in a very specific situation or specific circumstances. If you fit one of those situations, a trust might be right for you. For example, trusts are useful for things like creditor and divorce protection. Second, you can use a trust to keep more and better control over your assets by using the trust to give clear instructions for the use and management of your financial resources. A third reason you might use a trust in your estate planning is that a trust avoids probate. This is the one, quote, everybody knows. Probate has sort of become a four-letter word in the personal finance world, and everyone tells you to avoid probate if you can. The problem is no one really tells you why. Probate is the court case that transitions what you have to the people who should receive it following the directions in your will or under the law. As a court case, everything is public record. No or very little privacy is involved. And as a court case, at least one attorney is going to be involved, which costs money, often a lot of money. And the court system has its own costs too, plus probate often takes a long time, especially when there are complicated assets like a business or maybe deferred grain sales. So what is a trust? A trust is a relationship between three people: the grantor, the trustee, and the beneficiary. The grantor is the person who wants to set up the trust and is sometimes called the trustor or even just the trust maker. The grantor and the trustee agree together that the trustee will manage the assets according to the grantor's instructions and that the benefits of the trust will go to, you guessed it, the beneficiary. In this sense, a trust is really just a contract between two people that is intended to benefit a third person. As a contract, a trust will stay out of court unless something goes wrong. We enter into contracts every day, at the bank, at the dry cleaner, at the drive-thru, and none of those contracts go to court because both sides fulfill what they promised. Since a trust is a contract, it works the same way. As long as everyone does what they promised to do, the trust stays out of court. To put a really fine point on it, no court equals no probate. Because a trust is a contract, trusts are extremely flexible with what they can do, which makes them extremely versatile. In fact, they're so flexible that trusts can help accomplish all three of the purposes of estate planning. Remember, those are control while you're alive and well, instructions for the trustee to take care of you and your loved ones if you become incapacitated, and clear and detailed instructions for the trustee about how to handle your assets and who should get them when you pass away. There's so much to know about trusts, to be honest, that we'll be doing a separate series on this show to dig deeper. But there's one more essential detail that I want you to know about trusts before we wrap up. We describe a trust at our office as being like a bucket. When you create the trust agreement and the grantor and the trustee sign it, you've got an empty bucket. This is a problem because the trust agreement can only control what's inside that bucket. If it's empty, the trust doesn't do you any good. So the critical next step is to link your assets into the trust through a process we call asset alignment. This can be done using ownership changes or beneficiary designations, and it's so important that the trust is useless unless the asset alignment process is complete. Unfortunately, that's all we're going to have time for today. There's so much more to know about trusts, but fortunately, we've got a good baseline, a good introduction. If you have more questions about this or anything else we've talked about for the last several weeks, I'd encourage you to submit that question on the KSOU website. Just click Programs and select Siouxland Senior Planning from the drop-down menu to find the form. Thanks for listening. We'll see you next week. I always feel like it goes without saying, but please, please, please do not take legal action on your own because you heard it on this program. If you want to dig deeper on something you heard today, the Huizenga Law team would be happy to schedule a one-on-one vision meeting at our office in Orange City, where we can talk about your unique goals for your legacy. Just give us a call at 712-737-3885. You can learn more about elder law and estate planning issues on our website by visiting SiouxlandSeniorPlanning.com. And remember, it's not too late to protect everything you or your loved ones have worked so hard to build.